Good morning, ladies and gentlemen. My topic is if and how arbitral professional organisations should help regulate arbitrators, if at all, and their role in producing ethical and/or practice guides and enforcement. I've been a member, as you've just heard, of the Chartered Institute, in fact, for about 40 years, and indeed was its president in 2015, so it's fairly natural that I would focus on the Chartered Institute. But I'm not going to go in detail through their regulatory role, but instead I'm going to look at some, I think, more basic issues in this topic. When I started my preparation, it all seemed very straightforward, because we all know what we mean by the regulation of the professional and ethical conduct of arbitrators, don't we? Well, unfortunately, the more I thought about the subject and did some bit of research, the more the complexities of the topic seemed to be revealed to me. So much so that when I visited my dentist last week, I was lost in thought as I sat down on the couch. So I barely registered the needle he described with great understatement as a little scratch, and I didn't take too much notice of the 40 minutes of intense sensations with as many alien metal instruments in my mouth as he could put in at any one time, which he said might cause me some minor discomfort. At the end of the session, he then said, "Well, you didn't have much to say." Well, ignoring the obvious point that drills, suction tubes and an array of metal probes doesn't exactly encourage conversation, I explained the issue that's taking shape in my mind. Should arbitrators be regulated by the arbitral professional organisations to which they choose to belong? Can such regulation include questions of ethical behaviour? And to what extent should such organisations police or enforce the regulations? Now, to my surprise, my dentist then gave me a dental scenario, which I may come back to in a moment, because it's an area that we don't normally associate with adjudication. Not getting very far with this. So I might be now. Yes, good. No. Nope. Switch it off. Right. Well, that shortens it somewhat. Okay. Yep.
It will be these two.
That one. Oh, right. Jolly good. Well, I thought we better start with some definitions, which I'm not going to read out, but they do, I think, cover the three words that we do need to concentrate on, namely regulation, ethics, and ethical behaviour. And I think we can move straight on, because obviously time's going to be short. Now, that led me to what it means to the man in the street. And a bit of research suggests that it means a lot of things. It has to do with my religious beliefs. Being ethical is doing what the law requires. It's what my feelings tell me is right or wrong. And I think I like the last one. I don't know what the word means. And I was getting to that stage. But I did sort of eventually pull my thoughts together, and I came to the conclusion that I could probably put it in terms of three categories. The first one is where there's a clear consensus that the behaviour is unethical and is outside the expectations of an arbitrator, and can indeed be identified in the general law within a jurisdiction. The obvious example is an arbitrator whose behaviour creates justifiable doubt as to impartiality or denies a party a procedurally fair process. Such behaviour is clearly regulated either by common law, a common law concept of natural justice, or express provisions as to impartiality and fairness in arbitral legislation. The second category is, I think, behaviour that's generally held to be unethical, but there's yet not a clear consensus. In this category, arbitral organisations often develop regulations and provide guidelines as to best practice, but the behaviour may not be outside the expectations of an arbitrator as recognised by the general law. The extent and degree to which such regulation and guidelines are policed and enforced obviously differs between the organisations. Finally, you get the third category, where the general view is that it isn't behaviour that is unethical, it's ethical. But there's nevertheless a degree of unease. Given that such issues tend to be rather fact-sensitive, the behaviour may come within the catch-all offence that most institutions would use of the member bringing the organisation into disrepute. So a fairly catch-all way of dealing with this. Now, clearly society's views on such key principles such as honesty, fairness, equality, dignity, diversity, individual rights will develop with the passage of time, and what was perfectly acceptable 20 years ago is certainly not, and was probably then in my third category, may by 2018 already be in my second category and heading towards my first. And it's not a coincidence that I've got three categories for you, and of course the IBA with its famous traffic light three colours. I think the two meet one another to some extent. So turning briefly to the Chartered Institute, yes, it claims it is the worldwide largest training and arbitral accreditation organisation, 16,000 members, and to some extent its success depends on a continuing perception that in return for paying an annual subscription to use them, the post-nominal accreditation, for example, Fellow of the Chartered Institute, indicates that the holder has achieved and will maintain the highest standards of competence and professional conduct as an arbitrator. Now, it follows that members are required, must be willing to practice in an ethical manner and adhere to strict principles, which are set out in the Code of Professional and Ethical Conduct. So there you've got professional and ethical quite deliberately put in the same code. It serves as a guide to practitioners as well as to provide a point of reference for users of these processes, and the principles set out in the code also serve the purpose of promoting public confidence in arbitration and other dispute resolution techniques. The code expressly adopts the Oxford English Dictionary of Ethics, which I gave you earlier, and Part 2 of the code applies to the conduct of members when acting or seeking to act as neutrals in alternative dispute resolution processes, wherever conducted, whether or not they've been appointed to act by the Institute itself, and whether or not the process is conducted under the auspices of the Institute. So that's a pretty wide jurisdiction. For some of the arbitral community, including members of the Institute, there is a view that ADR is now a profession in its own right. I'm not so sure about that. I doubt it will ever be more than a secondary profession. That's in some extent recognised in the code, which makes the point that what it covers in its code may well be covered by primary professional organisations such as Bar Council if you're a lawyer. It's got 9 rules. They cover behaviour, integrity, fairness, conflicts of interest, competence, information, communication, conduct, the process, trust and confidence, as well as fees. And it's very short, less than 2 pages of A4. So it is quite deliberately descriptive, not prescriptive. It's policed by a professional conduct committee who may investigate all complaints against members of whatever nature, whether they relate to the appointment by the Institute, as I've said, and whether or not indeed the complaint relates to the member's conduct even as a dispute resolver. And enforcement is taken very seriously. The members of the PCC have one thing in common with the Supreme Court justices in America, that once they are appointed, they are in effect untouchable. The big difference, much to your disappointment I'm sure, is that they don't have to go through confirmation hearings, and so we never get excited by tales of uncontrolled beer drinking at university or other unethical, if not plain illegal behaviour. The sanctions open to the PCC are wide-ranging and include removal from panels which the Institute selects arbitrators for appointment from, and indeed suspension and exclusion from membership of the Institute itself. Anyone who's been a president of the Institute will always remember that a past president was in fact suspended for nearly 10 years when the PCC upheld a complaint, he'd been rather slow in reaching and publishing his award. Just being rather dilatory was enough to have him suspended from membership of the Institute for quite a number of years. So let's move on then. One that you won't hear from anyone else today is, I think, an interesting little rule that within a guide, and that's TEXA, that's the Technology and Construction Solicitors Association. It's associated with one of the divisions of the High Court in this country, and it does a lot of adjudication, if you like, the poor relation of arbitration. They include a duty to notify of judicial comments and criticism. That's quite interesting, and that is because of judicial criticism of a very well-known arbitrator and adjudicator, and as a result, they felt it was necessary to add that. So that's their way of adding to the body of what they consider by regulation to be unethical conduct or behaviour. Difficult dilemmas. Well, there's my dentist. And as time's getting short, I'll have to get it rather short. His example that he gave me was, a dentist is not allowed in the UK to use teeth whitening materials on anyone under the age of 18. A dentist was put up in front of the disciplinary committee of the dental body because he did so. He used whitening. Why did he use the whitening? Because the parents of a 14-year-old girl said she had had a tooth discoloured in a sports accident. She couldn't have any permanent solution for some years, and she was being bullied on social media because of a discoloured tooth. It was affecting her performance at school, and she was actually having counselling. And the counsellor's view was she needed tooth whitening as a cosmetic improvement, which would have all those other benefits. The dentist then decided to break the regulation, saying not under 18, for what he considered to be ethical reasons. That, I think, is the reverse of what we tend to be talking about. I've given you some examples of ones closer to home. If you're in an adjudication, I'm offered 2 on the same day. They're both to be finished in 28 days. Do I take the big ticket one or the small one? And the small one means that one of the companies involved in that dispute may go bust if they don't get a quick answer. Sole arbitrator deciding a jurisdictional challenge. If I answer yes, 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 you win. I answer no on the first point. Do I need to actually move to the second and third point to look at it? Maybe I do, maybe I don't. Telling war stories at conferences and arbitral meetings. Arguably, if one is not very careful, one moves into an area where you're not actually behaving in a particularly ethical manner. Changing times, they're changing fast. All from the same stable, arbitrator and counsel from the same barristers' chambers in this country. 30 years ago, no problem at all. Now it's seriously under question. Double hat, poacher or gamekeeper. Are you going to be a party representative and an arbitrator, or does a point come when you need to make up your mind to be one or the other? And how independent is the independent arbitrator? Most independent arbitrators, we're members of a number of arbitral organisations. So, enforcement as well. There's quite a lot of research that suggests that tougher penalties don't work. Expectation of being caught does work. Learn from mistakes. It should be a proactive rather than a reactive exercise. So my conclusions are there. I think regulation ethical behaviour is often conflated. I think it's rather too simplistic. Regulation, I think, will expand as and when there's a new consensus that a particular behaviour is unethical and should be regulated to remain in step with the general law as it applies to arbitrators. Arbitral organisations have got to remember that arbitrators don't have to join any of them, they choose to. And you don't have to be a member of any arbitral body to necessarily practice as an arbitrator. And finally, The overriding purpose of enforcement should be to improve standards and confidence in arbitration rather than to penalise. And just remember another area that doesn't normally feature in arbitration, dentistry. That gives us another example. Anyway, that gives you, I hope, some food for thought. Thank you very much.